afternoon, and thank you for joining us on TheCourt.ca. Our guest on today's current event segment is Professor Allan Hutchinson of Osgoode Hall Law School. Professor Hutchinson has been teaching for over 30 years on various topics, including public law, legal theory, and professional ethics. He's also legal counsel to the firm Roshan Geneva, LLP, and has special expertise in civil litigation, tort, and corporate governance. Welcome, Professor Hutchinson.
Thank you. Happy to be here.
So today, September 27th, is exactly 1 year since a tragic drunk driving incident took place in York Region, which claimed the lives of 3 small children of the Neville-Lake family, as well as the children's grandfather. The grandmother and great-grandmother were also injured in the accident, so it was a pretty serious catastrophe that took place. This case received national attention for many reasons beyond the sheer magnitude of loss. There was discussion in the media about whether our criminal justice system does enough to deter and subsequently punish impaired driving incidents. A lot of attention was also paid to the fact that the convicted drunk driver, Marco Muzzo, comes from a very wealthy construction development company. He subsequently pled guilty to numerous charges, including impaired driving causing death, and sentenced to 10 years. So national attention has now focused on the civil matter that is on the horizon in the news. So, given your expertise, we would like some insight on what you think about civil cases such as this one, where you have a loss of life to this extent. And why don't we start off with a hypothetical scenario? Parents that have suffered a catastrophic loss similar to the Neville-Lake family walks into your office. What do you do as a civil litigator?
Well, I think there are a number of things. First of all, there's a legal discussion about whether they have a basis for the claim. Okay. And I think particularly in the Muzzo case, it's rather straightforward, as he pleaded guilty to the criminal conviction, and therefore that ruling can be used in any civil action. But the usual issue moves on beyond a legal liability issue to an economic analysis, which says, even if you're successful in your legal claim, will there be any resources which you can access to satisfy the judgment? Because, as we all know, you can't get blood out of a stone. In this case, Muzzo, to talk in a rather callous language of the law, is a very attractive defendant. Not only would he have carried insurance, but his family would have enormous wealth, and also, if I understand the facts correctly, he was driving a car that was owned by his father's company.
Yes, that's correct.
This means that, in this case, it won't affect how much damages are awarded. That will be based on an assessment of the plaintiffs involved, but it will mean that if it exceeds the insurance limits that were on the car, then there will be some deep pockets which to extract the judgment from. And most lawyers, as much as they would sympathize with the tragedy of the event, would be quite happy to take this legal case, as while there will be some obstacles along the way, it seems a case in which the chances of success are extremely high.
Mm-hmm. And so to follow up on that, a lay person reading the news will see this big number, 22.5 million. Are you allowed to maybe walk us through, give us a little bit more detail on how you even come up with that number to begin with that we're seeing in the news?
Well, the thing to remember is that when you make a claim in a civil action, excuse me, you have to state an amount, and you can never recover more than you claim. Therefore, the incentive is to go high, because although you can be reduced in your claim, you can never exceed it. So a reasonable assessment of the damages in this case will be extremely high anyway, because there were 3 young children involved. And the 3 young children, in the rather callous logic of the law, will be worth a lot more than the grandfather. The grandfather would have less years to live, although the children weren't so much injured as killed. So 22 million may seem high, but it's not ludicrously so in a case in which 3 small children and a grandparent was injured.
Okay. And what percentage of these types of cases settle in Ontario? Can we even expect this to go to trial to begin with?
Well, on the facts of the Muzzo case, one would be very surprised to think it goes to trial. There's also no-fault insurance, and there can be litigation in these areas, but this would be an unlikely case. And even if it could go to court, The fact is that most cases that could go to court settle beforehand.
Okay. And what might be some negotiation tactics employed by maybe Muzzo's representation to get the number a bit lower? Because both sides are trying to basically come to terms that are most agreeable to their side.
Well, I think in this case, Muzzo made the important step of pleading guilty.
Okay.
And also expressing considerable regret and remorse over the event. This, of course, won't change anything. But I think part of his remorse and regret will be that he's expecting to pay a significant amount of money in this case. And although he will not be giving money away, or his family won't be giving money away, after all, he's in prison, then I think there's opportunities here for a significant settlement, although his lawyers will be keen to say that while they're willing to pay reasonable amounts, they will not be willing to pay over reasonable amounts. Mm-hmm. And so it's a matter of making the assessments about what the value was of the lives that were tragically killed in the accident, computing that, and then deciding what could be settled.
Mm-hmm. And if we were to take maybe a comparative look at the Canadian system versus the U.S. system, because it's not unusual to hear about tort cases there where it can go up into the hundreds of millions. Why don't we really see that in Canada? This seems to be one of the cases with one of the most larger settlements.
One of the things we tend to hear is trial court judgments in the States going for enormous amounts of money, but they often get cut back upon appeal. One of the main reasons in the States is that they give enormous amounts for pain and suffering, and we do not. Also, there is a concept of punitive damages in the United States, and although there's a possibility of punitive damages in Canada, they're rarely involved in these kinds of personal injury actions. Mm-hmm. So a combination of pain and suffering being higher and punitive damages in the States mean their awards are much higher than they are in Canada.
And our last question would be, do you think that this case in particular will have a lingering impact on our legal system? If so, how? And if not, why not?
I don't think it'll have any great legal significance. I don't see any special legal issues, at least as far as I'm aware of the facts, that will have some enduring influence on the law. What it might do, however, is underline further the dangers of drinking and driving and the catastrophic consequences that follow. And also in this case, I think there's a certain stereotype which is borne out by the facts of a young, rich, cavalier young man who at some level thought he was above the law and that whatever happened, his wealth and status would get him out of trouble. And the fact is, it didn't. And if there's a message in this case, I think that's the more important message than any legal message.
Professor Hutchinson, great insight. We very much appreciate your time. Thank you for being with us on TheCourt.ca.
Thank you very much. My pleasure.